Yes, Mr. Mumby.
My ladies and my lord, my learned friend followed the order of his skeleton argument through his 9 grounds of appeal. I propose to do the same. I will make 3 general overarching points first. 1 of law and 2 of fact. The first, the point of law, is simply that the application to lift the stay was before Mrs. Justice Bacon as the first instance judge, unlike the other points, which are a second appeal. This is accordingly an appeal from an exercise of discretion, case management discretion, by the first instance judge. I don't think the consequences of that are controversial in any way, and I don't think I need to take the court to the authorities that set out those well-known consequences that you have in the bundle. John C. Estates at tab 18 of the authorities bundle, and ABP Technology at tab 54. But I do say that those familiar principles give VACAR a formidable burden to discharge on this appeal. I do not think it will be controversial that a discretionary decision is a matter for the first instance judge. This court should not even look behind the exercise of discretion unless satisfied that it has been exercised in a way which displays an error of principle. That must be one of the 5 well-known types of error. 1, a misdirection of law. 2, procedural unfairness or irregularity, which isn't alleged here. 3, taking into account relevant matters. 4, failing to take into account relevant matters. Or 5, making a decision which is plainly wrong. In relation to all of those, and the last in particular, the role of the appellate court, to use the phrase from the authorities, is to police a very wide perimeter. And it is rare for a judge who has considered the relevant considerations to have come to a conclusion outside that perimeter. The weight to be given to the various factors is, of course, a matter for the first instance judge, to whom this court must defer, unless there's been a wholly unjustifiable attribution of weight. I don't take you to that, because I think those authorities are, those principles are ones that the lordship hear probably every day and are uncontroversial. But I do say they have to be borne in mind throughout. VACAR's appeal quite correctly purports to be in line with them. In my submission, this is one of those appeals where what one is seeing is lip service to those principles. In reality, this court is being asked to do is simply to remake a discretionary decision that the appellant didn't like. And I make that point at the start because it runs through everything. My second and third overarching points are points of fact. I will take a moment on them, although I know that you will be anxious for me to get to the substance of the complaints. The second is that there is a highly unusual factual feature in this case, very unusual in the context of an application to lift a stay, which in my submission makes it hard to see at the end of the day how any court could ultimately have reached a different decision. That is the feature that the actual matters in dispute in the State 1987 claim, by the time of the application to lift the stay, had already been bindingly determined between the parties at a trial, full trial, namely the trial of the 2017 claim before Examiner Judge Gerald. Examiner Judge Gerald determined, as we know, that the flat had always belonged to Iftikhar, never been held for VACAR. There's never been any appeal from that finding, it's accepted. And that means that before Mrs. Justice Bacon and before this court, it's common ground that there is no defence to the 1987 Act claim. So the question is, should a stay be lifted of a claim to which it is already known that there is no defence? And I don't think it's contentious, so I don't need to turn it up, but that concession is recorded all over the place. It's paragraph 137 of the judge's judgment, recital 7 of the judge's order. There's the transcript of it being made at the hearing. If it's needed, is in the supplemental bundle at tab 27, although I don't think it is needed because it's not contentious. And that concession is reflected before you in the fact that there is no appeal from the entry of summary judgment on the 1987 claim once the stay is lifted. The appeal is all on the lifting of the stay, and it continues to be admitted that once the stay is lifted, it must follow that summary judgment is granted on what is now admittedly a completely meritorious claim. It was suggested this morning that although the result of that claim is binding and is accepted, it was still open to Vacar to say that it was in some way unfair, although binding. That is certainly a point which hasn't been put in quite that way before this morning. It is, in my submission, a bad point. First, as a matter of principle, once one has a binding judicial determination between the parties of what happened, and it is not appealed, it is simply not open to a party to say, yes, that is binding, that is the truth of what happened as determined by the court, but nonetheless it is still in some way unfair to me. That is to strike at the very nature of what judicial determination is and the whole way the justice system works. There's also a second point, picking up on what my learned friend said this morning, that the ingenious point my learned friend made, that the unfairness he complained of wasn't an unfairness in what had happened before His Honour Judge Gerald. It was an unfairness as to the lack of availability of evidence by that time. Of course, a point that in practice would cut both ways against both parties. And given the nature of the judgment finally made, one can assume it would have been more unfair to my client, because we know my client was in the right. But the short answer to that point is that the suggestion that it was no longer possible to have a fair claim in the 2017 proceedings, in light of the long delay and in light of what had previously happened, the point at which that point naturally arose was before one got to trial of the 2017 proceedings. If it was a good point, the correct judicial response would have been, yes, there can be no fair trial of these proceedings, they're an abusive process, strike them out. And that is precisely what Vacar sought to do. He did apply to strike out the 2017 proceedings on the basis they were abusive and that a fair trial was no longer possible. That is what gave rise to the judgment of His Honour Judge Gerald, to which you've been taken various times this morning, behind tab 17 of the supplemental bundle. That's the first judgment of His Honour Judge Gerald, is in response, among other things, to that strikeout application. So the point was taken, and the point was rejected by His Honour Judge Gerald, it being inherent in that judgment, which my own friend took you to, that a fair trial was still possible. And indeed, subsequently it was conducted. Vacar didn't appeal against that decision of His Honour Judge Gerald, deciding that a fair trial was possible. If he was to take the point that he takes now, that the determination of the 2017 claim was unfair, that was the point for him to continue to press it, but it was determined against him by the court and wasn't pressed further. So, my ladies, my lord, that answers that point. And in any event, as I say, it's simply not open to a party that's lost a trial and doesn't challenge that result on appeal to say the result is unfair. Bottom line is that Vacar says that he now accepts that the 1987 claim has no defence. What flows from that? Several very striking consequences flow from it. First, because the merits are known, we now know that by refusing to lift the stay, the court would not therefore be doing what it normally does when it refuses to lift a stay, which is to deprive a party of a chance to pursue an uncertain piece of litigation. It is simply depriving Iftikhar of the flat that rightfully belongs to him and gifting it to Vacar, to whom it never belonged. Now, I accept that, of course, the courts have been known to take a hard line on procedural defaults, particularly in recent years, perhaps. But that is, in my submission, an astonishing, draconian and unjustifiable sanction for any breach that can properly be laid at Iftikhar's door of what he should have been doing over the intervening period. It is simply to deprive him of his property and hand it to Vacar.
I find a difficulty with this aspect, which is that the question whether to lift the stay or not is a binary question. It's a switch.
Yes.
If it's switched one way, we know that Iftikhar has an absolute right to the property. If it's switched the other way, we know that Vacar has established an absolute right, now unappealed, I think. Well, that could give to a right by adverse possession. He's i.e. Iftikhar's title has been lost. So it's not so straightforward to say this case is unusual because we know the outcome if the switch goes one way. We know the outcome if the switch goes either way.
Well, of course, what your lordship says is right in one sense, but in another sense, if one looks at the position within the 1987 claim, one knows that is a claim to which there is no defence. It is not said and could not be said that there is an adverse possession claim to that defence. And I made that quite clear this morning. So looking at that claim, one has before the court a claim which is unanswerable and unanswered. There's no defence. And the reason that is supposedly given for not giving effect to the right of the party, which is clearly established within that claim, is Iftikhar's procedural defaults. And that's what I say is a truly unusual position. So with your lordship's switch, one half of the switch is within the claim, the other half of the switch is extraneous to the claim. My lord, my ladies, the second point which flows from the fact that determination of the 2017 claim has been made is that one can now see the delay in progressing the 1987 claim in a very different light. Of course, Iftikhar does not deny that he has been at fault in various respects over the years in not progressing that claim. He's never denied that. He accepts that he's been at fault and that it's serious and significant. But we do now know that the root cause of all of the delay, the reason why we are still here in this year, rather than the matter having been resolved in 1987, because we know that it's what His Honour Judge Gerald held, is entirely Vakar's fault. His Honour Judge Gerald held, paragraph 25 of his judgment, that Vakar had been deeply manipulative and willing to do, say, or do anything to hold on to the property, the flat, which he knew and knows perfectly well was not and is not his. You see similar findings to the same effect other places of the judgment as well. Paragraph 74 is another example. So I don't say that Iftikhar hasn't been at fault. Of course, I accept that. But it is now, in my submission, impossible to overlook the fact that the root cause of all of this is that Vakar didn't, as he should have done, put his hands up, as he knew he should have done, put his hands up and hand the flat over in 1987, but instead concocted and maintained for years a series of dishonest defences and evasions. And the third consequence that flows from the fact that the 2017 claim has now been determined, which again makes this a very unusual application to lift a stay, is this. In any case management context where the court is debating procedural defaults and delays, and debating whether they should whether a claim should be allowed to proceed in the light of them, the underlying issues that weigh in the balance against allowing the claim to proceed are generally either along the lines that there is a risk of fair trial will no longer be possible, or along the lines that there is a risk, in particular under the modern regime, there is a risk that the defaulting litigation will be allowed to soak up an unfair share of the parties and the court's resources. In this case, one can see neither of those risks arises at all. There's no risk there won't be a fair trial. The trial's happened. In my submission, it can't be said it's unfair. There's no risk of further inappropriate use of the court's resources. If the stay is lifted, everyone agrees, one gets a summary judgment straight away. So that also goes to my submission that if the court were to refuse to lift a stay, if any court were to refuse to lift a stay, what one would be in would be the business of punishment, illegitimate and draconian punishment. My ladies and my lord, the third overarching point I was going to make before I go to the individual grounds of appeal does arise from the procedural history. As the court will have noted, and as is all over the papers, it was an important part of Mr. Jarvis, Queen's Counsel, might be convenient to refer to him as the Deputy Judge's decision in 2011 not to lift the stay, that he was proceeding on the clear basis that new proceedings would be able to be issued and And in those new proceedings, the true owner of the flat could be determined without any adverse possession defence being raised. And there's various backs and forwards we'll have today and tomorrow about how he came to that view. But it's absolutely clear that that is an important part of his reasoning, as was seen by His Honour Judge Gerald and was seen by Mr. Justice Bacon, and unavoidably my submission will have to be seen by this court. And it's also indisputable that at least he thought that it was based on what Vacar had told him and confirmed to him. And with apologies for showing you things that I know you have read already, I would just look out the relevant part of the Jarvis judgment, tab 11 of the supplemental bundle. I think, to be corrected, but I think not all of the relevant paragraphs were no criticism, but not all the relevant paragraphs that I would wish to refer to were referred to by my learned friend.
Sorry, we're at divider 11.
We're at divider 11, and we are on page 117. One looks at paragraph 116, where the deputy judge is considering the relevance of merits under the then version of Rule 3.9. And in the second part of that paragraph, beginning 5 lines down, he says it's one fact and one has to weigh it up in this way. The reason one takes into account the merits is because the court regards the declaration of purchase a legitimate claim, particularly a good one, as a very draconian step. However, as in this case, where the claimant can bring a fresh claim without prejudice to himself, then it seems to me the issue has little relevance. One sees the point again there, and I apologise, I know this must be very familiar to the court already, but one sees the point again at the bottom of that page in paragraphs 118 and 119, where he's considering another of the factors under the then version of Rule 3.9, which is the interest of the administration of justice. He deals in 118 with what further directions would be necessary. Of course, rather historic, as the matter was before Mr. Justice Bacon, because by the time we got to her, no directions were necessary. But then he says 119, administration of justice bears a slightly wider connotation than this. The emphasis is not on past event and what the court must now have regard to, but what the court must now have regard to is the consequence of any order it might make. And considering those consequences, I ask what the question identified earlier. If I refuse to lift this stay, what will happen to the claimant's claim? The claimant, if it wishes to seek possession, will be able to issue fresh proceedings. And there's no doubt that the primary issue that concerns the claimant is to get possession of the flat. And then one comes again and most clearly to it over the page on page 190 in paragraph 130. Obviously a very important consideration, under the then list of factors in the then version of 3.9, the effect which the grant of relief would have had on each party. To some extent I've already considered this. So far as Iftikhar is concerned, I've indicated he can bring a new claim. Initially the position was that it was contended on behalf of Iftikhar that he would be substantially prejudiced because his claim had been met with a defence of adverse possession. It was confirmed to me by Sarah and indeed by Vacar on Thursday and repeated to me again in court today that there was no claim for adverse possession, and so I discount that as a prejudice. It seems to me that it is, as I've indicated, far cleaner for a new action to be started. So there'll be further debate, I suspect, tomorrow about what Vacar meant to say and the extent to which that may result in an abuse of process defence to the 2017 claim. But what is beyond dispute, and which I rely on here as well, is that it is clear that Mr. Jarvis was proceeding on the basis and on the assumption that fresh proceedings could continue without an adverse possession defence, because that is what he'd been told by Vacar. And that was accordingly also would have been the assumption of everyone else who was there. In the event, what has happened is that new proceedings have been taken, which have established the issue that Mr. Jarvis thought had to be established, which was the true ownership of the flat from the beginning. And the only defence that has now been advanced as a good defence, subject to the appeal that I'll be pursuing tomorrow, is the adverse possession defence, which is exactly what Mr. Jarvis understood wouldn't be run. And I do say that that is a third overarching point which runs through all the consideration of this. I'll be submitting tomorrow that what was said in paragraph 130 and what underlay that judgment makes it an abuse of process for VACAR to run an adverse possession defence to the 2017 claim. But if I'm wrong about that, as Mrs. Justice Bacon thought I was, and that is the premise on which we're having this argument today, then in my submission the case for lifting the stay becomes overwhelming. Because it is an obvious and in my submission a monstrous injustice. If the net result of all of this intricate litigation is that VACAR is able to bank the continuation of the stays, which was continued on that basis by Mr. Jarvis, and also at the same time bank the benefit of the adverse possession defence. And that, it's my third overarching submission, that, as well as the fact there's been a trial which has determined all of this, is a very unusual factor of this claim, which when one steps back really makes it hard to see how Mrs. Justice Bacon, however she expressed herself, whatever the issues were, how she could ever have decided it differently, or how this court could decide it differently if this court were to decide it needed to. So with that preliminary, I will move to the 9 grounds of appeal. I'll take them in the same order as my learned friend. The first ground is that it is said, this numbering, I should say, it's my learned friend's numbering of this morning, it also matches the numbering sections D1 to D9 in the section headings of both parties' skeletons. So when I'm saying 1 to 9, that's D1 to D9. And if you ever want to know what each party said about the skeleton, that's how you find it. The first ground is the complaint that the judge failed to assess the seriousness and significance of the breaches Ipticar committed. Now, originally this complaint fell into 3 parts. My learned friend has narrowed that with a very proper concession this morning. It is now, as I understand it, no longer said that the judge failed to take into account the breach of the order for payment of security of costs in the period up to 2011. That had been characterised as the first breach in my friend's skeleton. That's no longer pursued, as I understand it. It's now accepted that, reading the judge's judgment, she must have had that in mind. Equally, the second point, second breach, as per my own friend's skeleton, which was that the judge didn't take into account the fact that for the period up to 2011, from 2000, there was a failure to apply to lift the CPR, the automatic CPR stay. That's also no longer pursued because it's recognised that the judge, reading her judgment properly, must have had that in mind. So those realistic concessions for which I'm grateful. So I don't need to take your lordships back through the early parts of the judgment, which show perfectly well that the judge was very alive to that history and had been through it in detail, nor the detailed analysis I was going to do in the relevant paragraphs to show why she plainly was referring to those delays as well as the later delays. The point which is still live is a submission that although the judge took all of the breaches into account, she did not sufficiently assess the seriousness and significance of those breaches. Now, that, in my submission, with no disrespect to my own friend, is a manufactured complaint, which is a complaint of the nature that, well, the judge could have said what she thought more fully. That's always true. She could have reasoned it out more expressly. That's always true. But in my submission, there is no realistic basis to suggest that she did not have well in mind the serious significance of those breaches and reach a view on them. The suggestion made, I think, below friend Skeleton, that it wasn't enough to say they were serious and significant. They should have been described as very serious and significant, extremely serious and significant. That's not the sort of complaint that goes anywhere. It's a trivial drafting matter. And even as a complaint of substance, what it's actually saying is, I don't like the judge's assessment. She assessed them as serious and significant. That was the appropriate way she thought to describe them. I say she should have said they were more serious than she said. But that's a complaint about the weighting of the factors. That's exactly the sort of complaint you can't make on an appeal. It was conceded before the judge, and conceded here as well, of course, by Iftikhar, that the delays were serious and significant. And if you, the court flicks open the judge's judgment, and there will be a much thumbed passage by the time we've finished. Tab 14 of the core bundle for those who still have it there. This is page 200, paragraph 135. She begins to record submissions. She records my acceptance that it had to be approached on the basis of relief from sanctions and of the applicability of the Denton test. She summarises the Denton test in a short form, which you might think is appropriate for someone who's not in contention. And then at 136, the first thing she said is, in that regard, Mr. Lumby accepted the delay was both serious and significant, said there was good reason for it. And that's why she doesn't need necessarily to spend a lot more time on it if she thinks that concession is a fair reflection of how serious and significant it was. It is right to say that the concession had been put a bit more fully in the skeleton argument that was before her, where we had expressly conceded that it had led to increases in court cost and court time. That was paragraph 82 of our skeleton argument before her, on page 222 of the supplemental bundle. She obviously had that well in mind and didn't need in my submission to spell it out in the judgment. Equally in my submission, she obviously knew and understood why it was serious and significant. We'd made that concession. She had been taken repeatedly through the relevant parts of the Jarvis judgment and obviously knew well what the points were there. And the submissions have been made to her. As for the suggestion that she should also have taken into account that the delays had led to an unfair trial in 2017, well, that wasn't in my submission put squarely to her, that the trial before his Honour Judge Gerald had been unfair in the way it was put this morning. And in any event, for the reasons I developed at the outset, in my submission, it's a bad point. It is right that Vakar made the point below that delays have made the trial harder because of fading memories and lost documents and so forth. And of course, that was perfectly apparent to anyone, including the judge looking at it, and is fairly included within the concession that the delay was serious and significant. Again, she didn't need to spell that out. What one comes back to is that Mr. Justice Bacon obviously understood the points that were being taken. She was very alive to those points about the waste of court time, about the loss of evidence. They would all have been included within her acceptance of the concession that the delay was serious and significant. And it was a question for her whether she considered that they were so much more serious and considerate, so far at the upper end, that she needed to make more of it, and she chose not to, and that was totally for her. It's also, in my submission, worth reflecting on the effect of the court acceding to these sort of submissions. And I come back to the point here, which is the point I started with, that ultimately what one is doing here is unpicking the paragraphs of the judgment and criticising the way it's been drafted. And in my submission, one could always do that with any judgment. There's always more that could have been said. It could always have been set out more fully. And if one accedes to that sort of submission, where there is no real complaint that the judge has overlooked important matters, what one creates in this court is a trap for first instance judges. And without wishing to make overuse of the word floodgate or anything of those of that kind, in my submission, this court does need to be careful about judgments which set the bar too high for the fullness with which the reasoning for a case management discretion has to be set out. Those are decisions the courts make every day. So that was what I wanted to say on the first ground. The second ground is that the judge should have regarded herself as bound by conclusions supposedly reached by Mr. Jarvis, Queen's Counsel, at the time of the attempt to lift the stay in 2011, applying the then version of CPR Rule 3.9. To the effect, it is said that there was not a good explanation for the delays, and that those delays gave rise to a significant risk that a fair trial would not be possible. And my submission will be that this goes nowhere. The finding that is said to be made isn't made when one looks at what the judge said. It wouldn't have been binding in any event as a matter of issue estoppel, which is what my learned friend says he needs to make the point. I'm sorry, which is the way my learned friend seeks to make the point, at least primarily. And in any event, the circumstances and the evidential position had moved on significantly by the time one was in front of Mrs. Justice Bacon. Taking first the supposed conclusion there was no good explanation for the delays, what is actually said is in paragraph 125 of Mr. Jarvis's judgment. It's in Supplemental Bundle Divider 11, page 119. What he said was,
That's paragraph.
125.
Thank you.
What he said was, I'm not sufficiently satisfied on the evidence that provides an explanation for this enormous period of delay. So what he was expressly doing was saying that for the purpose of the exercise he was doing, on the evidence before him, he wasn't sufficiently satisfied he'd been given an explanation. That is not a binding finding, that there was no good explanation which would stand for all time in other proceedings. That's just not the way it's expressed. That's my first point. And by the time we got before Mrs. Justice Bacon, the evidential picture had changed, as we had by that time the benefit of His Honour Judge Gerald's findings at trial as to what had in fact happened during that period of delay, as to what had been agreed in 1991, 1992, and the way in which the parties had conducted themselves. As the court will know, that's paragraphs 82 to 88 of His Honour Judge Gerald's judgment, running to the conclusion that in 2010 that both Iftikhar and Vacar regarded themselves as released from the family dispute resolution mechanism, if one can put it that way, and able to pick up where they left off. So that was a set of findings which had been made by then. Parking for a moment whether those findings were binding or not, they were a set of relevant factual findings made by a trial judge about what had happened during this very period, which obviously revised position from what it had been in front of Mr. Jarvis. Second point. Third point. So first point is he didn't express himself as making a final conclusion on the point. Second point is by the time we got before Bacon, the position had changed anyway, because there were now findings about what had happened during that period. Third point is that whatever conclusions he did reach didn't, in my submission, give rise to a binding issue estoppel. What he was making was a case management decision on written evidence about the lifting of a stay, and what he said about the explanation for the delay wasn't a finding, it was an assessment of the evidence before him as a factor in that overall discretionary case management decision. My friend took you this morning to the passage of Spencer Bauer at 8.02. I wouldn't disagree with the principles there set out. In my submission, insofar as it matters, what one is seeing in this paragraph of Mr. Jarvis's judgment is not a finding fundamental to his decision giving rise to an issue estoppel, as opposed to an evidential conclusion or a part of his reasoning that leads up to it. This is the same point developed in Spencer Bauer throughout that chapter, and particularly at paragraphs 8.23 and 8.24, which I should perhaps show you for completeness. I'm not sure they add a great deal, but I should show them to you. That is Authorities tab, Bundle 2, tab 71. And a lot of the passages, I'm afraid I, for whatever reason, don't appear to have bundle pagination in my authorities bundle, so my referencing may be a little less smooth than my learned friends. But as you turn the pages of that extract, just after the passage my learned friend cited in 8.02, you jump straight to a page which has 8.23 at the bottom.
That's page 1463.
I'm very great. As I say, I apologise for not being able to give the court those references as we go. For whatever reason, I don't seem to have them in
Paragraph
my
numbers
bundle.
are absolutely fine.
But familiar principles, the determination must be fundamental, not collateral. Only determinations which are necessary and fundamental will do so. Necessary fundamental decision. Other determinations have a positive do not. And various authority is then set out. And relevant to look at what's said by Justice Dixon in Blair and Curran in the middle of the page, which at least in part may repeat what my own friend showed to you this morning. I think it's the same paragraph, in fact. One's looking at that same distinction between findings which are fundamental to the decision and findings of a deliberate and formal which concern only evidentiary facts, not ultimate facts forming the very title to rights. Decisions upon decisions on matters of law. So, insofar as material, I do say that what Mr. Jarvis was doing here was not giving rise to issue estoppels. That's
This
my
is a
third.
point against you as well, in the sense that the findings that you like at 82 to 828, you accept are not binding anyway.
Well,
Come
those.
to another part of the case.
Well, we come to it's on Judge Gerald's findings. Your Lordships
Oh, I'm sorry. I am
referring to.
Yes, that's what I mean. I thought you were that. Yes.
Yes, no, I'm here making the point against my learned friend on Mr. Jarvis's findings. I won't accept that the position is the same when one's in front of
Right.
His Honour Judge Gerald, and we may come to that.
Yeah.
But partly because what he's doing is rather different. He's determining the matter at trial, and he's making findings to which these are, in my submission, necessary steps. But there's also this difference, that where I rely on those, just to pick up the point now since your Lordship raises it, where I rely on those, I do say it doesn't ultimately matter whether they were binding or not. They were findings which had been made by a trial judge who'd heard from these parties very recently. Whether or not they were formally binding as a matter of issue estoppel, it was entirely reasonable for Mrs. Justice Bacon to be taking them into account and giving them very serious consideration. So that's when which the position isn't parallel. But I think my learned friend, to make his point realistically, needs to say not just that Mrs. Justice Bacon should have made more of what Mr. Jarvis says, he needs to say she was bound by it. Because plainly she was aware of it. Plainly she was factoring into her overall decision. He needs to say she was bound. So, my Lord, picking up on the list I was in previously, my lady's picking up on the list I was in previously, my fourth point is that, in fact, these issues as to reasons for delay and as to possibility of a fair trial were all revisited without difficulty in front of His Honour Judge Gerald in 2019 in the context of the application to strike out the 2017 claim, and different conclusions were reached. They weren't treating as that strikeout application wasn't approached correctly, wasn't approached on the footing that it was already determined by binding issue estoppels created by the decision of Mr. Jarvis. And to make a fifth point in this run of points, my Lord Mr. Justice Lord Justice Zacaroli rightly raised this morning the question of change of circumstance, whether that was a necessary requirement. If and insofar as it was a necessary requirement for reaching a different conclusion from what Mr. Jarvis had concluded. There were, on any view in my submission, multiple material changes of circumstances since the matter had been before Mr. Jarvis. First, the question of whether a fair trial would in fact be possible, not just whether there was concern about it, but whether it would in fact, when it came down to it, be possible to have a fair trial, had in fact been argued in the strikeout application in front of His Honour Judge Gerald and determined. That's one highly material change of circumstance. The second highly material change of circumstance is the trial had in fact taken place and the merits of the underlying case were known. A point which I fear I will ultimately weary the court the number of times I'll make it, but it's, in my submission it's central. Third, again, point I've already made, we now had a set of findings of His Honour Judge Gerald, paragraphs 82 to 84, as to what had been happening during the years from 1987 through to 2010, which findings were not available before Mr. Jarvis. And a fourth change of circumstance was that Vacar was now running the adverse possession defence in answer to fresh proceedings, which Mr. Jarvis had understood he would not be running. So if one needs to look for material changes of circumstance, there is an embarrassment of riches. It is right to say that Mr. Justice Bacon did not specifically refer to paragraph 125 of Mr. Jarvis's judgment, at least in this section of her judgment, but it can't seriously be disputed that she wasn't alive, that she was alive to it, had read it, had had it cited to her, and was alive to the point. It had been cited in the skeletons, it had been cited orally. And so again, insofar as the point is not she was bound, but is merely she should have made more of it, it's another point which is really about wanting to disrupt the weighting that the first instance judge gave to different things, or wanting her to have spelled out more fully every point in her response to it. Moving then to the supposed conclusion that there was a substantial risk that a fair trial would not be possible, which, as I understand my own friend's argument, is the other thing that he says was bindingly determined by Mr. Jarvis, as well as there being no good explanation. The same suite of points essentially apply, same suite of points I've just made, or at least the points about the issue of estoppel and about it having been determined by His Honour Judge Gerald and about the change of circumstance. So points 3, 4 and 5 on my list all apply. It is also right to add this, that again, if one looks at what Mr. Jarvis was saying, what he was concluding, it is certainly right that he was saying a trial would be difficult, and he referred to fading memories and so forth, but he plainly didn't think and plainly wasn't purporting to conclude that a fair trial was impossible, nor was he concluding in my submission that there was a substantial risk that a fair trial would not be achieved. And I say that because the whole rationale of his judgment, in the passages I took court to earlier, is that no harm is done by refusing to lift the stay, because Iftikhar can pursue new proceedings. If his view was that a fair trial wasn't possible, that plainly is not how he would have looked at it. And one sees the same thing also, interestingly, in one of the post-judgment exchanges between bar and bench at that hearing, which is in the supplemental bundle tab 12. Page 124. Conveniently confined just at this page, I believe. This is discussion between Ms. Tipple's Queen's Counsel, as she was, and Mr. Jarvis, Queen's Counsel, as the Deputy Judge, discussion of the draft order. And the question is raised, my lord, what is to happen in relation to action 4267? And then the judge says, well, I refuse to lift the stay on both of them, but I haven't dismissed. Do I need to make that plain as well as a coda? Obviously should be the other sort of coda with an A on the end, on the ER. That I've merely lifted the stays and I have not dismissed either action. And then it's not entirely clear what's said by Ms. Tipples. But the judge says, well, your applications have been dismissed, but I haven't. What I mean is I haven't struck out the claims. And then he says, because do you remember that because of those underlying costs which would depend on the merits? And then there's another slightly unclear statement by counsel, and then the judge says, that's what I had. We dealt with an argument and I didn't deal with it in the judgment, which is why I'm showing this part of the transcript. And counsel says, that's right. So the status, and the judge says, I think everyone agreed that that was the right course, so that in the event that if this does go to trial, if you do start new proceedings, if you do, then a judge will finally determine that, and those costs that are picked up, underlying costs, then they would have to be dealt with by application as a result, because there are costs in cause and so forth, weren't there? And Ms. Tipple says that's right, she's content with that. And the judge says, if you don't start a new action in a certain period of time, I imagine someone will say, well, they better be struck out and you better pay all the costs. And then Ms. Tipple says something, and Ms. Mather's counsel for the trustee says, my lord, on that note, and it's inaudible, obviously the stay will remain subject to resurrection, either at the end of new proceedings before tidying up and dealing with costs. So very clearly one sees again there that what Mr. Jarvis envisaged was not a situation where there was difficult as the trial might be, and relevant as that might be to whether it was appropriate to have an old proceedings or new proceedings. He plainly didn't envisage that there wouldn't be a trial because it couldn't be fairly done. He thought that's what was going to happen. I also, while we're here, so we don't need to come back to it, but it'll be relevant for future points, it's very clear from this that he understood the proceedings still to be extant, absolutely express he hadn't struck them out, and he was absolutely express that if someone did want to get rid of them, they would need to come back and apply to strike out. It was also clear that he envisaged that at the end of the day, once the merits had been determined in new proceedings, the stay would in fact be lifted, at least to the extent of dealing with costs, and presumably any other consequentials. So that takes one to the end of ground 2. Again, in my submission has nothing to it. Ground 3 is a submission that the judge was wrong to take into account Vacar's failure to progress the dispute since 1987. And that's a point not about my overarching point that the whole thing was Vacar's fault in the sense that he should have accepted at the beginning that he had no offence. It's a point about Vacar's more specific procedural defaults in not advancing matters. The 2 points I make on that, sorry, I'm so sorry, the 4 points I make on that, 2 of law and 2 of fact. The first point is a short one. Rule 3.9 required Mr. Justice Bacon, among other things, to consider all the circumstances of the case. And that is reflected in the 3rd limb of the Denton test, where all the circumstances of the case have to be considered. And that is a short answer to my learned friend's submission that this was all just irrelevant. Well, it wasn't relevant. The question of whether culpability was shared is plainly a factor to be taken into account along with all the others in the exercise of the judge's discretion. It's not right to say there was a closed set of what was relevant and what was irrelevant. The second point, which is another point of law, is that Vacar's submissions on this ground are premised on the idea that a defendant can simply allow sleeping dogs to lie. I think, having heard it developed in submissions, it's our common ground, as my own friend now puts it rather, that point isn't put in relation to the period since the CPR came into force. So I think it's probably accepted, corrected doubtless, that at least that way of putting the point doesn't work for the years from 2000 onwards. By that time,
one can't let sleeping dogs lie since the CPR.
as I understand it, that was part of what my learned friend was saying this morning, that this is I understood how he was putting it, except that since the CPR comes in, you can't let a sleeping dog lie, but as he says,
I didn't understand
well, maybe I'm being corrected right now.
What I intended to say, probably did it very badly, was that I accept that one can't just sit back and then claim prejudice caused by the delay, but that doesn't stop you relying on the Limitation Act.
Yes. Well, the Limitation Act, I'm going to come to in a little bit of detail. That's the next ground of appeal. Here one's talking, as I understand the point, about prejudice caused by delay. That's the nature of the third ground of appeal. So I do make the point, whether it's conceded or not, that at least since the CPR came into force in 2000, it's not right that a defendant is entitled to let sleeping dogs lie. So insofar as that is implicit in this criticism, it's a bad criticism for that period. I would also make the submission that what one is now applying is the rules under the CPR. That's what's being applied by Mr. Jarvis under the then CPR in 2011. It's what's being applied now. So, while of course it might be relevant to have regard to what were the expectations placed on the parties by the court at the time, it's not the case that one can simply say the CPR approach is irrelevant to anything that happened before 2000. And the third point, which picks up an exchange between my Lord Justice Zacaroli and my learned friend this morning, well, maybe I go further than either. My submission is that this debate about whether one can let a sleeping dog lie under the authorities one's talking about, the Burkitt line, and then the post-CPR version, is in a sense slightly off topic, because there one is looking at whether the claim can be struck out as an abuse of process. Here one is looking at whether Vacar can properly complain of the delays which he says have caused prejudice. And where that is the nature of his complaint. In my submission, under the old rules or under the CPR at any time, it's obviously material to look at to what extent the complaining party has contributed to the delay. So those are the 2 points on the law. I then have 2 points on the facts. First, the point on the facts is that one has to have in regard here that this was not a totally straightforward situation of a claimant and a defendant in one set of proceedings, in which the running was all one way. The truth is that the position in 1987 is that there were 2 sets of proceedings going in different directions. The 1987 action, the possession action and the partnership action. The 2 were completely entangled with each other, procedurally. At the actual point where matters went to sleep in relation to those proceedings, what was going on can be seen in the judgment of Mr. Jarvis, which is of course tab 11 of the supplemental bundle. That's the summary that my friend took at the court through this morning. And effectively the last thing that had happened was what was described in paragraph 50 of this judgment, page 105. It describes the position in July 1988. There were 5 applications at a hearing before Mr. Justice Knox, 3 applications in the partnership action relating to various matters, numbered 1, 2, and 3 in this paragraph. And there were 2 summonses in the 1987 action, all coming on together. And those were Vacar's summons for an order, and this relates to the security for costs order, which is the mainspring of many Brunner-Friends points. Vacar had an application for a summons that unless Iftikhar paid 25,000 into court, paid the money into court, the action should be dismissed with costs. So Vacar had an outstanding application to upgrade the stay in the security for costs order into an unless order, again struck out. And Iftikhar had a cross application for an order that the order of Master Monroe, that's the same one, be varied as to the stay. So what one sees at the moment where the music stops isn't just a claimant who's let sleeping dogs lie. It is a truly entangled procedural situation in which both parties have applications, cross applications, proceedings against each other, all locked up together. And indeed, the things which were put to sleep included Vacar's summons, seeking to get the action, seeking to get the security for costs order turned into an unless order to get rid of the action. And equally, Iftikhar's application, trying to get the stay varied. So that's the first factual point I wanted to make, that it's just not right to characterise this as a situation where there's a claimant who should have been proceeding matters and a defendant who is entitled to sit back. You have a completely entangled procedural situation with the matters that are put to sleep or let to go to sleep, including what should happen to the very security for costs order the complaint's now made in relation to. And in my submission, that makes perfectly understandable the concession which was made to His Honour Judge Gerald in 2019 that both brothers were equally at fault for the delay, and also the significance which Mrs. Justice Bacon attached to that concession, among all the other matters which she had in account. And the second point, factual point, is that it is also, for another reason, not right to regard Vacar as a mere defendant. A position totally analogous to a mere defendant who might have been allowed to let sleeping dogs lie, whatever the phrase is. Because in practical terms, he knew that the pendency of the 1987 claim was the roadblock to him being able to get title to the flat registered in his name at the land registry. A little bit of law in a moment, a little bit later on, but my own friends exegesis this morning of the law of limitation and the new title which vests in the adverse possessor from the moment they take possession, subject to third-party claims, from McGarry and Wade, goes so far as it does, but what he didn't address, which is also relevant to this point, is the fact that this is registered land. And we'll come to some of the statutory provisions in due course because they're relevant to the next round of appeal. But the practical upshot is, if you're the adverse possessor of registered land, then if you sit still, the paper title owner carries on being registered. They're on the register, all the world can see them. If you want to become the registered owner, you do actually need to do something and get the land registry to put it back into your name. And in this case, Vacar knew all about that because, as is recorded in Mr. Jarvis's judgment, he'd applied to the land registry for that to happen in 2000. And the land registry's response was, effectively, well, no, because the 1987 claim is still pending. So the stay will have to be lifted and that claim will have to be resolved one way or another. And one sees that, various places where one could look, but it's convenient to see it in Mr. Jarvis's judgment, which may still be open before the sum of your ladyship's and your lordship. Paragraph on page 109. Paragraph 74, you see it recorded that Vacar applied to HM Land Registry to claim title to the flat by adverse possession. as is normal, the land registry notified the registered proprietor's solicitors. I should say that the first part of that paragraph where it says, although it apparently bore no relation to the fact there was an automatic stay, the parties no doubt were oblivious to this. I think that in fact, it may be the case the stay is mentioned in the application to the land registry, so it's not material, but I just mentioned that. But he records there the application was made, and then in 77, paragraph 77, he says what happened to it. Correspondence continues with the land registry. The land registry suggested to Stevenson Harwood it would be better to the parties to proceed with the application to the Chancery Division. Cook Matheson, Vacar's solicitors, replied there was a misunderstanding, invited an explanation as to how those could be reopened, given the stay. And the land registry on the 1st December told Cook Matheson, as Vacar's solicitors, that it could apply to lift the stay. There's then correspondence arguing about who should lift the stay. So again, one has a reason why, yet another reason why delay by Vacar was significant, because this was a case where it being registered land. He knew perfectly well that the question of ownership of the land remained open so long as the 1987 proceedings were pending. So those are my submissions on the third ground. What one comes back to is the first of them, that Justice Bacon was required by Rule 3.9 and by Denton to consider all the facts of the case. And in the procedural history of this case, the fact that there was culpable delay on Vacar's part as well as on Iftikhar's was a material consideration, among all the others. I should say there was a submission when I first got in paragraph 98 to the effect that the judge considered Iftikhar's breaches as unimportant because Vacar was also in breach. That wasn't developed orally, and I apprehend may not be pursued. To the extent that it is, it's my submission, that's not a fair characterisation of the judge's judgment. Nowhere does she say that Iftikhar's breaches were unimportant. She plainly didn't consider them unimportant. She started from the proposition that they were serious and significant. One then gets to ground 4. The main point here is the suggestion that the judge should have had regard to the supposed fact that lifting the stay was depriving Vacar of title to the flat. Because I think it is said that he had already acquired title by lapse of time because the first set of proceedings had been stayed or permanently stayed, to use the phrase that my learned friend lifts from Lady Justice Harden's judgment in Offalu and Bossert. Now, the point as I understand it is that based on the authority, the first point is that based on the authority of Offalu, Vacar had acquired title to the flat because 12 years had run. The effect of the 12 years running was to extinguish, was not just, as in the case of another type of cause of action, to bar the claim, but was to extinguish Iftikhar's title to the land, or would have been if it were unregistered land. And then, as one follows through the provisions, as I will in a little later, it is being said that the effect therefore was that he'd acquired title under the machinery which causes the same practical consequence to follow in the case of registered land, which is section 75 of the old Land Registration Act, and then the transitional provisions of the new one. And it said that's the case notwithstanding the fact the 1987 claim was still pending, because it had been stayed. And it said on that basis that the judge was undermining the policy of the Limitation Act by disturbing a title acquired by Vacar. I'm going to make submissions on the 3 broad heads on this point. The first is that, the first broad head is that Offalu and Bossert does not support the proposition that Vacar needs. It does not support the proposition that when possession proceedings issued within the limitation period are stayed, permanently stayed, whatever that may mean, the effect is equivalent to a dismissal. So that the adverse possessor acquires a complete title notwithstanding the continued existence of the proceedings. The second broad heading is going to be that even if Offalu did support that proposition, it's plainly distinguishable on this case. Whatever a permanent stay might be, if there is such a thing, the stay in this case was plainly not one. And the third broad head is going to be in relation to the policy of the Limitation Act. I will say there is no principle that the court must further the policy of the Limitation Act when exercising its case management powers in the sense of invariably pulling within the ambit of the Act proceedings which it can pull within the ambit of the Act. Of course, where the Act applies, the court applies it. There are some procedural contexts where the fact that pending proceedings are preventing limitation from applying will be a relevant consideration. But it is not right that the court should always be seeking to ensure that any claim it can is barred. Obviously not. So, the first of those heads, Offalu doesn't support the proposition that a stay is equivalent to a dismissal for limitation purposes. What we are talking about, which is the high watermark I would submit to my own friend's submissions, is what Justice Arden says at paragraph 64. We'll look at that in a moment. I will be saying, so you know where I'm going, that it's not relevant to the appointed issue in the case and was accordingly obiter, that it's expressly based upon a concession, that it has to be read in light of the fact that proceedings with the prior claim had in fact been dismissed, not just stayed, and that if Lady Justice Arden was saying what my learned friend says she was saying, which my submission is not clear that she was doing so per incuriam prior authority, without the benefit of analysis, which would have shown that it plainly wasn't right. And of course she was doing those things because it wasn't actually an issue, it wasn't a point argued before them. Even Lady Justice Arden, as she then was, may not, when expressing a point obiter in those circumstances. So if one opens Offalu, it's tab 29 in the first authorities bundle. As you've heard from my learned friend's opening of the case, there had been a prior set of possession proceedings in Offalu, and this was a second set of possession proceedings. And if one looks first at paragraphs 4 to 6 on page 6 of the report, you see that 4 to 6 a summary of what the issues were on the appeal. First was a human rights point. The second was a point about intention to possess, arising from the fact that Bosserts had claimed to be in possession of tenants. That's all about animus possidendi, with which we'll be entertaining your ladyship's lordship tomorrow. And third, there was a point about an alleged acknowledgement of title. There was no issue before the court about trying to bring the previous proceedings back. So the issue which we're concerned with, which is whether you can revive the previous proceedings, was just not an issue in Offalu. Nor was there any point being taken that the previous proceedings had stopped time running during their pendency. And that point wasn't taken because it wouldn't have been right. It's established, as is recorded in paragraph 72 of the judgment, that once a claim for possession has been struck out, even if it was issued in time, as it were, retrospectively, that doesn't stop the clock having run during that period. So there was no live issue before the court concerning whether the effect of a stay or a permanent stay was tantamount to a dismissal. It wasn't relevant. My learned friend showed you on page 12 paragraphs 23 and 24 summarising what had happened in relation to previous proceedings. Namely, they'd been stayed, there'd been an application to lift the stay, it was refused. That's all we're told. We're not told why it was refused, we're not told what the reason was, we're not told what the parties then did, presumably because none of that was important. It was all just background. It wasn't important what had happened, why the previous proceedings had their stay refused. There was no argument about it. As my friend rightly says, we know that in fact, although this isn't mentioned here, we know from the report of the case in the House of Lords that shortly after the refusal to lift the stay, the earlier proceedings had in fact been struck out. It's common ground, so I won't turn it up, but if it's helpful to have the reference, that's paragraph 18 of the House of Lords decision, which is behind tab 30. So if one then turns on to paragraph 64, I'm sorry, if one turns on to paragraph 58 on page 22, we're at the start of the consideration of the intention to possess point, the animus possidendi point, which was a point in issue. And that's analysed all the way through paragraphs 58, 59, 60, 61, 62, and it is then concluded in paragraph 63. In which the court decides whose submissions are to be preferred on the point, which in this case was the adverse possessors. Paragraph 64 doesn't form any part of that analysis. It's, a phrase I use without disrespect, it's an afterthought. And what is said there is, it's moreover clear the inception of the first set of proceedings would have stopped time running so long as those proceedings were on foot, but not thereafter. But at that point, no one was suggesting the contrary. And indeed, it wouldn't have been a sensible thing for anyone to suggest because, in fact, the first set of proceedings had been struck out. So the case was on all fours with Markfield. There's no profit to anyone in trying to say that there was a point about this. And Lady Justice Arden then says, in my judgment, this principle must apply where proceedings are permanently stayed, as the first set of proceedings were stayed in this case, and Mr. Wilson has not suggested otherwise. And Mr. Wilson hasn't suggested otherwise because it's not a point that's an issue, it doesn't matter. So my first submission is, this isn't dealing with a point that's an issue. It is Lady Justice Arden noting, explaining a part of the surrounding legal scaffolding in which they're arguing. It is for that reason in my submission, this is my point A, overturned, it's not authority. My point B, it's expressed that what she's saying is based on a concession or a lack of argument from Mr. Wilson. And that, of course, in practice will be because there's nothing profitable to argue about. So again, for that reason, in my submission, it won't bear weight, even as a matter of persuasive authority, let alone binding authority. Third, point A and point B is point C. The phrase permanently stayed, what does that mean? In my submission, it's cryptic. The mere fact that the previous proceedings had been stayed under the automatic stay when the CPR came into force, as in this case, obviously didn't make it a permanent stay. Practice Direction 51 envisages a case that's been stayed in that way coming back before the court for the court to decide what to do with it. Express power to lift the stay. So that obviously didn't make it a permanent stay. The fact there'd been an attempt to lift the stay which had failed, it's hard to see how that could have made it a permanent stay. In principle, a party can always apply again if there's new evidence or if there's a change of circumstance, so long as the proceedings remain live. I suppose it might be the case, we don't know, that when dismissing it, the terms in which District Judge Lightman had dismissed it made it apparent that it would be impossible in practice to make a further application. But that's not explained. In my submission, even then, it would be hard to describe it as a permanent stay. In my submission, reading all of this against the background that it received quick treatment because it wasn't an issue and wasn't important, the answer to the mystery is probably that the proceedings had in fact been struck out. And in that sense, the stay had become permanent. And so there was no profit in anyone suggesting there was anything other than a permanent stay. So that is my offer as to how to reconcile what Lady Justice Arden may have meant by permanently stayed, or in any event, how it could have come to be the case that concessions were made to her, that the stay was permanent. It now was, the claim had been struck out.
It's not right in any event, is it, to say that the commencement of proceedings stops times running in any sense at all, other than you've brought your proceedings in time.
Correct, Mark.
So if the first set of proceedings were still continuing, this may be a ridiculous and impossible scenario, but the first set of proceedings were still continuing and a second set was then started. In the second set, the time bar would apply if it was outside the 12-year period, irrespective of whether the first set was still existing or not, wouldn't it? Because it's not relevant to whether time runs. Time is running.
My lord, indeed, which is why it's important whether the first proceedings have been stayed or struck out.
Well,
and if they're stayed, whether the stay can be lifted. I think your lordship's legal analysis is correct. But if I'm wrong about that, and what Lady Justice Arden was saying, obiter and evidently without consideration, which she hadn't had submissions, it wasn't important. If she was saying was that there was such a thing as a permanent stay, which is equivalent to a dismissal for these reasons, she would have been wrong about that for a number of reasons. First of all, because it would have been per incuriam, the earlier decision of the Court of Appeal in a case called Roffa Sport Management and DHL, wasn't cited in Offalu. That is further back in the same authorities bundle at tab 9. And while it's never classy for counsel to go straight to the head note, it's irresistible, I'm afraid, for me to do so in this instance. Held, dismissing the appeal that a stay of proceedings was not equivalent to dismissal or discontinuance of those proceedings, and an action in which all further proceedings have been stayed, even if by consent of the parties, remained in being. This was a case in which the relevant stay had arisen pursuant to a settlement, and there was then thereafter an attempt to add parties to the proceedings for various purposes. If one goes forward within the report of the authority to page 910, there were various points of issue. If one goes forward to page 910, you see Lord Justice Neal at the end of a learned treatment of the history of stays, say, beginning at the first paragraph, I've come to the conclusion, however, it would not be satisfactory at the present day to seek to draw a line between stays are absolute, stays are conditional, and then to equate absolute stays with orders of dismissal or discontinuance. Stays are granted in many different circumstances. The width of the jurisdiction is underlined by the wording of the Act. She then sets out. In addition, the court has inherent jurisdiction to stay under a number of different rules, powers to stay proceedings under different statutes. Many instances where the court has power to grant a stay, where the order is not conditional in any ordinary sense of the term, but where a change of circumstances may make a further application to the court desirable. And he then gives a number of examples. He gives an example of an arbitration stay, or a stay on foreign non-convenience grounds. In such cases, the chances of the actual proceedings running may be remote, but difficulty in the arbitration or decision of the foreign court to decline jurisdiction may make it desirable to revive and continue the state action. Then he gives an illustration and cites from Lord Justice Diplock in relation to that, and that takes up most of the rest of the page. And then if one goes over the page, in my judgment, for the sake of clarity and certainty, the word stay in an order should not be treated as a possible equivalent of a dismissal or a discontinuance. There may well, of course, be cases, however, where the person who wishes to have the stay removed will face great difficulties. An action which may be stayed by consent following a compromise provides an example, but as it seems to me, the action following a stay remains technically in being. The action cannot proceed or resume its active life without an order of the court, but I do not consider that it can properly be regarded as dead in the same way as an action which has been dismissed or discontinued by order. So that is my submission, the authoritative answer to what is a stay and what is the effect of a stay. And the answer is, however difficult it may be for the stay to be lifted, or however unlikely, stay proceedings remain in existence. That shows that it cannot be right to draw the conclusion which my learned friend says was drawn by Lady Justice Arden in Offalu. It also goes to show in my submission that permanent stay is a misnomer. There are no permanent stays. A stay is not the same as a dismissal or a discontinuance. So it would have been in curiam prior Court of Appeal authority if Lady Justice Arden had been saying that. A consideration of the principles and the practicalities also shows in my submission why the law cannot be that. As to the principles, limitation is a creature of statute. It's clear that the statute doesn't apply to a claim issued within the limitation period. That's why the wording of the Act is always along the lines of no action shall be brought after time X. In the case of land, as my learned friend submitted this morning, once time has run, there is the additional feature that the title to the land, at least for unregistered land, is extinguished. That, and I'll turn the provision up if I may, which is tab 60 of bundle 2. That's the actual time limit we're all talking about. That's the UC section 15. No action shall be brought after 12 years. So the action brought within that time isn't court. And if you go forward to the extinction provision, that's section 17, a few pages on through this tab. At the expiration of the period prescribed by this Act, for any person to bring an action to recover land, the title of that person to the land shall be extinguished. So again, that's by reference to the same period. So it only is going to apply, the title is only extinguished if a claim has not been brought by the end of the limitation period. So if a claim exists already before the end of the limitation period, title insofar as reflected within that claim is not extinguished and is capable of being vindicated by that claim. And just so that the court has how this works, it is that machinery which, while that's the machinery for unregistered land, was then carried over under the old registration regime. If the court goes back to tab 57, you see section 75 of the old Land Registration Act. Apply to registered land in the same manner and to the same extent as they apply to land not registered, except that where, if the land was not registered, the estate of the person registered as proprietor will be extinguished. That's section 17 of the Act, which is looked at. Such estate shall not be extinguished, but shall be deemed to be held by the proprietor for the time being in trust for the person who, by virtue of the said Act, has acquired title. And then subsection 2, any person claiming to have acquired a title under the Limitation Act, the registered estate in the land may apply to be registered as proprietor thereof. And 3 then deals with what the registrar is to do on such an application to the registrar. And just so what's meant to happen is that the squatter applies to the land registry to get their new title registered, which is, as you know, what happened in this case unsuccessfully because the land registry said the old proceedings are still pending. And just to complete this run so that you have the statutory provisions, That was the provision under the 1925 Act. Tab 64 then gives you the transitional provision, which is paragraph 18 of Schedule 12 to the 2002 Land Registration Act, where registered estate in land is held in trust for a person by virtue of that provision immediately before the coming into force of the relevant section of the 2002 Act. He's entitled to be registered as proprietor of the estate. So if time had already run in your favour under the 1925 Act, your title would carry forward on the 2002 Act. Of course, all of this is vitally relevant to this case because this concerns events during that time period. It's somewhat historic and makes somewhat ironic the debates we have about the policy of land, of limitation in the context of land, that in respect to events which have happened since then, since the coming into force of the 2002 Act, as the court will be aware, a totally different regime applies, which is very, very materially less generous to the adverse possessor. And the policy considerations which motivated the law in the old days before 2002, which I have to accept still underlie the law that your lordships are applying, are not ones which were thought to be worthwhile ones for Parliament to continue from 2002 onwards. So this case is in many ways one of historic interest, though vital to the parties. But for the purpose of the current submission, what one gets to is the point that once a possession claim has been issued and is on foot, it is absolutely clear under all of that statutory machinery that it is not caught. And that really is the end of the point. Obviously, if the claim is dismissed or discontinued, as it in fact happened in Offley, then it no longer exists. And the point falls away, and all the limitation machinery will simply apply. But when it's merely stayed, I say, the claim still exists, and there is simply no statutory basis for the claim to be caught by the limitation period. And therefore there is no statutory basis on which a party in Vacar's position can say, because the claim was stayed, permanently stayed, whatever that means, I have acquired a complete title. No, the title, any title he acquired, was always subject to the 1987 claim, which is why he couldn't get it registered at the land registry.
But the consequence of the stay continuing on the 1987 proceedings is that the finding of adverse possession in the 2017 proceedings is valid, isn't it? And would give Vacar the title, or the entitlement to be registered.
Well, subject to the 1987 proceedings.
But if they just remain stayed?
Well, if they remain stayed, they're still there. It's still a blot on the title. How the land registry would cope with that position, if an application were made to the land registry following trial of the 2017 claim, I can't claim to know how the land registry would respond. It might be that they would say, as they'd said in 2000, well, no, because the 1987 claim has to be dealt with. Perhaps they'd be prepared to effect a change subject to suitable reservations and notes on the face of the register. The title was subject to the 1987 claim. I wouldn't, in my submission, have been open to them simply to ignore it. There would have been no statutory basis for that. And looking at the practicalities as well as the statute, I mean, the fact there's no statutory basis for what's said is enough, but looking at the practicalities of my submission, it's also clear the law can't be as Vacar says, and suggests that Lady Justice Arden said it was. Even if there were a statutory basis for treating some stays as disposing of an action, it obviously isn't the case that every stay is to be equated to dismissal or discontinuance of an action. Cases are stayed all the time for all sorts of reasons. So to make sense of what was said, one would have to be, what's now said, one would have to be looking to decide whether a stay is a permanent stay or not. Well, there's no test for a permanent stay, it's an invalid category. If it was a category that had life only for this purpose, it would be a very odd way to decide title to land. You had to look at the nature of the stay and the current status within those proceedings. The court had to decide whether that stay could properly be characterised as permanent or not. Just a matter of practicality in my submission, that cannot be the way in which the law of limitation works. And as I've already submitted, possibly ad nauseam, it's not the way the land registry considered the law worked when the application was made to them in 2000. And indeed, as I understood one point of the submissions that's made this morning, my learned friend accepts that the fact that there is a limitation defence accrued outside the scope of the 1987 proceedings, or of any proceedings issued within time, would not necessarily and in all circumstances prevent the lifting of a stay, except that there be exceptional circumstances where it might be appropriate to do so. In my submission, that's a telling submission, because once one accepts that there are some circumstances in which it will be appropriate to lift a stay, then it can't be the law, as Lady Justice Harden is said to have said that it was, that a permanent stay was tantamount to a dismissal. And it can't be the law that Vacar can say, I already had a title which, by lifting the stay, Mrs. Justice Bacon disturbed. He never had a title in respect to the 1987 claim. Once one accepts that there are any circumstances where it would be appropriate to lift the stay, one is accepting that he didn't have a title. I would also make the point, which doesn't totally fit in this run of points, but it now seems an appropriate time to make it, that the example my learned friend gave, which was of a party in Vacar's position saying, don't worry about the limitation period, is, in my submission, exactly what Vacar did say, effectively before Mr. Jarvis in the year 2011. So perhaps telling it, at least since 2011, my learned friend's exceptional circumstance actually has occurred in this very case. But that's another point. It doesn't, all of that's without prejudice to the overarching submission that it simply cannot be right that Vacar can be said to have acquired a title which the revival of the 1987 proceedings disturbed. What I've said so far is, on the law, I first broad heading, and you'll be glad to know the longest one about what Offalu does or doesn't decide. The second heading of my submission is that even if I'm wrong about all of that, and there is some sort of creature called a permanent stay.
Sorry to just go back to this, but
Oh, of course.
in the 2017 claim, so assuming that's it ends where it ended before Mrs. Justice Bacon, for the moment that Vacar had a right to adverse possession.
Yes.
You would say really that he hasn't got enough by that because the 1987 claim is still on foot until it's dismissed. It's still there. But you made the point about the land registry would be in a quandary as to what to do. What does, I mean, he's got an order for he gets an order for possession, doesn't he, under that from the court in the 2017 claim?
Well, we don't know what order would have been given because that wasn't the finding that His Honour Judge Gerald made. So one's in a hypothetical as to what order His Honour Judge Gerald would have made had he found there was a valid adverse possession claim.
Well, I suppose it's what order would Mrs. Justice Bacon have made, having allowed the appeal at that point? If she hadn't gone on to deal with the stay, what happened next?
One's again in a hypothetical. Well, if the submission would have been made, should have been made in this counterfactual on Iftikhar's behalf, well, hang on, there's the revival of the 1987 proceedings still to be dealt with. Had that been where matters ended before His Honour Judge Gerald, the submission would have been, well, the 1987 claim is still pending. We'll have to decide what should happen to that. I'll be applying to revive it, to lift the stay, as subsequently happened. And that would doubtless have prompted a counter-submission that would have gone, well, no, that's not right, presumably based on what my friend says today. But then it would doubtless also have been added, well, we'll cross-apply to strike it out. And the point would have come to a head in that way.
I'm sorry to interrupt. I just thought it might be helpful to draw attention to paragraph 11 of Mrs. Justice Bacon's order, which is not being appealed. Page 169 of the core bundle.
I'm grateful to my friend for drawing attention to that. In my submission, it doesn't really advance matters because that's what happened, not in the counterfactual, but in the actual situation we're in, where the order was made in 1987 to revive the 1987 action.
It sounds like under that order, if the stay hadn't been lifted, there would have been an entitlement to be registered, even though the 87 action had not been struck out. That's the premise of
Well,
paragraph 11.
I mean, in my submission, one could read it that way. That's not a safe way in my submission in which to read it, because what it's addressing is the situation which had in fact occurred.
It does say, but for the above order made in the 1987 action.
My lady, yes. I can't recall there having been discussion as to the formulation of that part of the order. It may be the explanation is the one I've just advanced, that having dealt with the but for the above order, one didn't need to address the further question of the strikeout, because the above order had been made. It may be that it was regarded as obvious by Mrs. Justice Bacon, and indeed by everyone, that at the stage we're now at, we're now at the stage where, in any view, we're at the end of the road, as it were, that if the stay were to be not to be lifted now, strikeout would follow as a consequence, which obviously was not the position when one was in front of Mr. Jarvis. And the 2 points were therefore the flip side of each other. It's not an order within my submission I need to hear, because it must in any event be part of the general appeal from the decision of Mrs. Justice Bacon on the 2017 claim. So it must be within the scope of the appeal. If a technical point that this isn't appealed is taken, I think the technical answer must be what it is.
No, maybe got to.
Actually. So I'm grateful to my own friend, but in my submission that goes nowhere. I think I was answering your Lordship's questions to what would have happened. I hope I've sufficiently done so. My Lord, yeah, my Lord, my Ladies, yes, I'm being reminded that it's on the appellant's notice on page 23 of the bundle. That paragraph of the order is within the paragraph which are appealed.
Thank you.
I was going to make a submission which I can hopefully make more briskly, that even if I'm wrong about what I've said and there is such a creature as a permanent stay, this plainly isn't a case where there is such a permanent stay. I've just made 3 points on that, which are similar to points that you have previously heard me make. One is that at the Land Registry in 2000,
Yes, we have that point.
to the view that wasn't permanent. Grateful. Second is your Ladyship, and indeed the whole court will also have this point, the way in which Mr. Jarvis approached in 2011 plainly didn't regard the stay as permanent. It's in the position that suffers the dispute going on to trial. And on that, my own friend says that Mr. Jarvis would have or should have struck the claim out if he was asked to. In my submission, that plainly isn't right. He wasn't asked to, so it's a hypothetical question. It's absolutely clear he didn't think that he was doing that. And it is also absolutely clear that he didn't think it was right to do that if the consequence would have been to hand Vacar a complete adverse possession defence. And also, that's the third point I was going to make under this heading, it is obviously not right to say that the stay was permanent in the sense that it could not be, the decision to lift it couldn't be revived. It obviously could on a change of circumstance. And I made the submission earlier that there have been an absolute plethora of changes of circumstance. I won't weary the court by listing them again, but I think I listed 4
Those, thank you.
earlier. My third point, my third broad heading on this ground of appeal is a slightly broader one, which is about the point that the court should be upholding the policy of the Limitation Act. It's obviously correct the court will apply the Act where it applies, but that doesn't help VACAR because we're in a position where on its face the Act doesn't apply to the 1987 claim. VACAR only gets the benefit of the Act if the court helps him out by refusing to lift the stay and indeed then striking out the 1987 claim. And in my submission, it's not the case that the court is under a general obligation to widen the bounds of the Act by getting rid of pending cases and pushing cases into the arms of the Act. Of course, there are procedural situations where the fact of limitation period has accrued but for pending proceedings is relevant to the exercise of the court's discretion in all sorts of ways. But that is not to say it's a general policy that the court should be, in all such cases, going with the result that favours the limitation period having applied and the claim being struck out. The entire claim being struck out. And in a way, the submission is obvious, I don't want to labour it, but there is a collection in paragraph 84 of our skeleton of various examples of the court in all sorts of different circumstances exercising case management discretions with the effect that the claimant is allowed to continue with an in-time claim, thereby avoiding a limitation defence which would otherwise have accrued. I think we cite there 4 cases, and one is Arab Monetary Fund and Hashim, which I'm not sure the specific facts matter, I'm not sure I need to turn it up, but it's a clear example of the court exercising case management discretion, in that case consolidating claims in a way that confers a limitation advantage. The case my own friend took you to, ST and BAI, is another example, in fact, in the context of extension of time for service of a claim form. Now, that is obviously a specific procedural context where the limitation implications are particularly acute, because one's looking at the time when the limitation period applies, which is when the claim is brought, and there is an obvious problem with parties bringing a claim just in time and then stalling service so that in fact the defendant doesn't know about the claim and the thing never gets out of the blocks. It's a sort of obvious, that's an obvious workaround, if I can put it in that way. And so obviously it's a case where the court is, as reflected by Rule 7.6 and also by the authorities, particularly astute to limitation consequences. But even there, it's not a decisive consideration. It's an important one, but the court looks at it among all the other factors. And we also cite there Pakistan and Jar, in which Mr. Justice Marcus Smith, although he didn't need to do it, seemed to have compassed lifting a stay in proceedings which had been imposed in 1954, many years later. And there's another instance given in Cable and Liverpool, Victoria, where there have been abuses of process in issuing a claim on a particular footing during the limitation period. The court nevertheless allowed the claim to proceed and therefore the claim to survive. And of course one can multiply many such examples, partly why I don't go to those cases in particular. So one comes back to the position that the policy of the Limitation Act does not require the court officiously to push claims into the arms of the Act. The fact that limitations expired is part of the picture, but not determinative. And in our case, there can be no dispute that Mrs. Justice Bacon was well aware of the fact that limitation had expired but for the 1987 claim, based on her conclusions in the 2017 claim, and that lifting the stay would therefore enable Iftikhar to obtain relief he otherwise would be barred from obtaining, and would cause VACAR not to be able to advance the defence he would otherwise be able to advance, and therefore not be able to have the flat. Indeed, that it would prevent him from obtaining title. She was well aware of that, it's apparent from the paragraph we've just been looking at in her order. But it's also obviously the premise of the entire debate before her. So if my learned friend's point boils down to not a point that based on Offalu, Vacar already had a settled title, which Mr. Justice Bacon was disturbing. And as I've submitted, that's not right. Vacar did not have a settled title Mr. Justice Bacon was disturbing. Because of the pendency of the 1987 claim, he didn't have a settled title for the purposes of that claim. Once one puts that to one side, and the submission becomes simply, well, Mrs. Justice Bacon should have made more of the fact that the effect of her decision was to apply my Lord Justice Zacaroli's switch, that if Takar would prevail rather than Vacar, and if Takar would get the flat, which otherwise he wouldn't, and Vacar would not get the flat, which otherwise he would for limitation reasons. Well, that's obviously the consequence of what she was doing. That's the whole premise of the argument. And the submission that Mrs. Justice Bacon didn't take that into account, didn't regard that as significant, is in my submission an unreal one. The weight which was to be attached to it was, of course, a matter for her. And so this, I've taken a long time on this ground of appeal because it's the one which seems most to have piqued the interest of Lord Justice Snowden by giving permission, and because it's the one which appears at first blush to have some law to it. But when one looks at it in my submission, it comes to the same thing as all the others. It's really a way of saying, I don't like the weight that Mrs. Justice Bacon attached to the factors, and I don't like the way she exercised her discretion. Dressed up as she didn't lay everything out as fully as she might have done. So, well, that was the fourth ground. The fifth ground is that Mr. Justice Bacon was supposedly wrong to hold that if Takar had acted reasonably in not applying to lift the stay while the 27 proceedings were on foot. The 2017 proceedings were on foot. Now that, I note at the outset, is a point on any view that the judge addressed. It's not a complaint that she overlooked something or included something immaterial. The point is put in terms of an error of principle, but the principled error isn't easy to identify. It's really another complaint that Vacar doesn't like how much the judge did or didn't attach to the point. It is right that the judge does not lay out the ALDI guidelines, which now tell you what you should do if you are pursuing one set of proceedings and you have a second set of proceedings up your sleeve, which is bring it before the court so the court can decide how to case manage that situation. The judge didn't refer to the ALDI guidelines, which isn't surprising given that, to the best of my recollection at least, it wasn't suggested to her that she should apply to them, that she should apply to this context. And I think I'm correct in saying the other authorities which were cited today in relation to this ground were not ones which were at least developed before Mrs. Justice Bacon. But it is obviously right that she would have been well aware of the desirability of related issues being determined together. And she was well aware of Vacar's submissions to the effect that Iftikhar should have made the application earlier, which is why she was dealing with the point at all. So my key submission here is that the court shouldn't be going into this because it's just a reopening of the discretion. Even if one does go into it, there's ample basis for the judge's decision on the point. This is not a case in which a party has kept a point up their sleeve or behind their back. Learned Friend took you to it in Iftikhar's reply. It was open on the face of Iftikhar's pleaded case in the 2017 claim that he had as a fallback point the ability to apply to lift the stay in the 1987 claim. It was pleaded openly on the face of the pleadings in the 2017 claim. He'd raised the possibility in correspondence, which you were shown. And it is right, as my learned friend says, that the response from Vacar wasn't along the lines of, well, don't worry, we can deal with it later. But it also wasn't along the lines of, well, if you're running that point, what we need to do is get it squarely in front of the judge at the CMC so we can decide how to case manage the 2 points. It's perfectly open to Vacar if the application of the ALDI guidelines was important, to take that stance then. Instead, the stance taken was, no, don't do that. In circumstances where it was perfectly open on the face of the pleading, the Iftikhar's stance was that it was open to him to take the point and to take it later. It's also important in the context of one of my friend's submissions about putting cards on the table and the defendant, or sorry, the claimant doing more than simply warning there should be another action, but making it possible for the court to manage the issues. It's important to be realistic. This is not a case where there's one claim and the party has another claim it could choose to issue. This is a case where there are two sets of pending claims. If it was important to have them dealt with at the same time, Iftikhar could have said that. Equally, Vacar could have said it. Equally, the court, if it thought it important, could have said that when the CMC occurred in the 2017 claim. We don't know what happened at the CMC, or at least I don't know what happened at the CMC in the 2017 claim. I'm told that it was Tipple's QC, as she then was, who was attending for Iftikhar, and I'm afraid we don't know what occurred. But this issue is one that, if it was to be taken, could and should have been addressed then. Even if there was some force to the criticism of Vacar, to the criticism of Iftikhar, that he should have brought this forward previously, which in my submission there isn't when he was being perfectly cards on the table. But even if there was force in that criticism, the consequence of a party failing to bring its claims forward or failing to comply with the ALDI guidelines isn't at the flick of a switch that the second claim is abusive and is struck out. It's the beginning of a debate as to whether there's been an abuse. It's the beginning of the broad merits-based assessment of all the facts, which is inherent in any argument on abuse. Familiar principle, Johnson and Gorwood, and all the subsequent cases. Johnson and Gorwood is in the bundle tab 22, the relevant famous passage on page 31. But the same principle is in all the cases, including, I believe, in ALDI. And at the end of the day, this complaint that Iftikhar should have gone earlier was one that was made to Mrs. Justice Bacon, and it was for her to decide how much to make of it. And she decided not to make very much of it, which my submission was a very understandable thing for her to have done and the right thing for her to have done, but in any event was something that was for her, not for this court. One also has to be realistic as to what the difference would have been if there had been an earlier application to lift the stay in the 1987 proceedings. It couldn't realistically have been dealt with before the trial. And the likely outcome is probably that it would have been adjourned to be determined at or following the trial in any event. We would have ended up essentially where we are now anyway. And Lord's ground 6 was that the judge failed to have regard to the specific factors mentioned in the CPR Rule 3.9. That was developed very, very briefly already by my learned friend, and in my submission, rightly and realistically so. It really, in my submission, is a make-weight point. T.H. White and Denton is the leading case on the application of Rule 3.9. The judge was referred to that. She summarises in paragraph 135. It is obvious from that she had well in mind the considerations in Rule 3.9, which is what the Denton criteria are all about. And that is what she applied through the following sections. And it simply cannot, in my submission, seriously be submitted that she was not taking those factors into account. The factors, as the court will be aware, are all the circumstances of the case, so as to enable the court to deal justly with the application, including the need for litigation to be conducted efficiently at proportionate cost, and to enforce compliance with rules, practice, directions, and orders. And in my submission, there's no force in the idea that Miss Justice Bacon failed to do that, and indeed no particularised complaint is made. That takes one to grounds 7 to 9, all of which relate to the point about Vacar's evidence put forward in 2011. There had been an oral agreement in 1991 or 1992 to withdraw or discontinue all of the claims which were then pending. Now, it was clarified, as I understood it, and rightly this morning in response to a question from my Lord Justice Zacaroli, that it is not being said that this consideration was one which dictated the way in which Mrs. Justice Bacon should have determined the case, or barred the approach that she took. It is being said that it is a factor she should have taken into account, along with the others. And so my overarching submission on all of this is that she did, she assessed it, and for a variety of reasons she gave it pretty limited weight, which reasons were perfectly reasonable ones, but at the end of the day it was a factor that she plainly did address. As to the specific complaints, the first one, ground 7, is in many ways the key one. This is the complaint that the judge was wrong, it was said, to hold that Vacar needed to have adduced evidence within the application if he wanted to make this point. In my submission, there's a very, very short answer to that. There was an order by consent made on the application to lift the stay. It's in the supplemental bundle, tab 24. And that order laid out a timetable for the service of evidence in the usual way, including evidence in answer and evidence in reply. And Vacar elected to serve no evidence in answer to the application to lift the stay. And the point's really a simple one. If he wanted to rely on factual matters as a reason to oppose the application to lift the stay, he needed to file and serve evidence in accordance with the order, and he didn't. And what the judge did at paragraphs 139 to 140 of her judgment was to hold him to that in what was, in my submission, a completely straightforward and vanilla application of the normal everyday rules of civil procedure. If a party is directed to serve evidence in answer and elects not to, then it is not open to his counsel to adopt at the hearing a witness statement from another application 10 years previously to run a point. The evidence which is being relied on in this application has to be served in this application, even if only in a witness statement which cross-refers and adopts, but it has to be served. So the parties know what the evidence is, the court knows what the evidence is, it can be verified by a current statement of truth, and the applicant has a proper opportunity to put in reply evidence if so advised. And that, in my submission, is the end of the point. If that procedural point were not enough, there is the added consideration, which also one sees picked up in the judge's reasoning in my submission, that it is plainly not the case that one can assume that what Vacar was saying in the 2011 witness statement is still his evidence. And that simply underlines the inappropriateness of allowing it to be adopted now. In our skeleton argument, we give one very, very obvious example, which is that in the 1991 witness statement, in the 2011 witness statement, Vacar's case, and the central point, was that the beneficial owner of the flat was his father, Bilal. And as you'll know from the judgment of His Honour Judge Gerald, that was his stance in 2011 because he was bankrupt at that time and engaged in what the judge obviously regarded as a cynical attempt to stifle interest by his trustees. So the case is actually set out in that witness statement, and you see it throughout. It's stated expressly, paragraph 5, paragraph 9, is that the owner of the flat's Bilal. Well, obviously by 2017 that wasn't what he was saying. He was saying the owner was him. It was a completely fundamental change in the story he was telling. Another example is that in 2011, in the witness statement, what Vacar was saying was that the agreement was not just that existing proceedings would be discontinued, but that there would be no future proceedings. That was the point which was debated this morning in relation to paragraphs 3 and 9.1 of the witness statement. I won't get back to them because they were looked at. But as my own friend rightly said in the end, based on paragraph 9.1, and my submission is true even paragraph 3, in 2011, Vacar was saying that this was an agreement which involved discontinuance of existing claims, no new claims in future, and was also bound up with the property going into the hands of the father Bilal, so it would become his to be dealt with. Well, that part as well had totally dropped away subsequently. Zacar never said in response to the 2017 claim, well, hang on, we agreed in the 1991-1992 agreement that there'd be no future claims. But if he was maintaining his 2011 evidence, that would have been an obvious thing for him to have said in response to the 2017 claim. So as soon as one actually steps away from the theory of these as different points and looks at the reality of that witness statement in which he's describing one agreement, all of the other material parts of which had ceased to be part of his case by 2017 and by the time we were in front of Miss Justice Bacon, certainly, it becomes really an astonishing submission that he should have been allowed simply to say, well, that's obviously still my evidence, and that Mrs. Justice Bacon should have allowed that. There's also a further point, which is that even if Zacar were entitled to bring back in his 2011 evidence, it actually doesn't go anywhere in circumstances where Zacar had expressly conceded there was no defence to the 1987 claim. A supposed agreement to discontinue existing proceedings in 1991-1992 is not said to be a substantive defence to the claim. It's said to have been relevant to the decision whether to lift the stay, to be taken into account as a factor that Zacar was asserting this. Well, Mrs. Justice Bacon took it into account to the extent that she could, which is that a submission was made by my learned friend to that effect. She took that into account. And you can't criticise her that she went no further than that and didn't attach weight to the point in circumstance where the evidential position was as it was. As I read my learned friend's skeleton, I'd understood at one point that it be his case, this may well be me misreading it, that this effectively barred the ability to lift the stay. This was a triable point, and therefore, because there would have to be a trial of it, it was impossible to lift the stay. As I understand it, that's not, in fact, what he says. He says simply it was one factor to be taken into account. Perhaps analogous to the way in which one would look at a dispute over the existence of a jurisdiction clause or something like that, when it comes up to a preliminary stage. It doesn't have to have a trial of those questions. There are various different principles depending on what context one's looking at the jurisdiction clause, whether it's an application to serve out or an application to stay or on the basis of breach of foreign jurisdiction clause, or whether it's an application for an anti-suit injunction or whatever it may be. But all of those tests involve one version or another of the court doing the best it can based on the written evidence before it, rather than having to have a trial. And in my submission, if one says, well, did Mrs. Justice Bacon do the best she could on the written evidence before her? Yes, plainly. That point really kills all of these complaints, but I'll say a few more things very briefly about grounds 8 and 9. I'm very conscious I want to leave my learned friend at least some time before we reach the end of today. Ground 8 was that it was wrong to take into account that Zacar hadn't pleaded the 1991-1992 agreement as an answer to the 2017 claim. And it's said by Zacar, by my learned friend, that that was wrong because the 1991-1992 agreement was irrelevant to the 2017 claim. So, the first thing to say is that this ground doesn't go anywhere if I'm right on the last ground. If I'm right that the failure to file evidence was a good answer to all of these points, then it goes nowhere. But also, it wouldn't have been irrelevant to the 2017 claim if Zacar was in fact still standing by his 2011 evidence. Because, as we've seen, and again I don't need to go back to it, when you actually look at the 2011 evidence, it doesn't just allege an agreement to discontinue existing proceedings, it alleges an agreement to discontinue existing proceedings and not bring new ones. So it was obviously perfectly correct and reasonable to take the view that the failure to make that point, which would have flowed from the same evidence, was a material factor in suggesting that Zacar no longer maintained this evidence, or insofar as he did, that there wasn't much meat to be attached to it. Because if the 2011 claim was true, it would also have afforded him a defence to the 2017 claim. So again, in my submission, the judge was well within her rights on that ground too, to refer to the fact that it hadn't been pleaded in the 2017 claim, and to regard that as a reason not to give weight to the point. And then the final point was that the judge was supposedly wrong to take into account his own Judge Gerald's findings about the 1991-1992 agreement. Again, I say this point doesn't arise if I'm right for the on ground 7. But I do say in any event that it was perfectly reasonable for the judge to take into account the findings which had been made by His Honour Judge Gerald as to what had occurred.
We have what you say at paragraph 100 of your skeleton argument on this.
Maybe I don't need to say very much
I'm just conscious
more
that
than that.
Mr. Jordan would like to say something in reply, no doubt, or because
I'm sure.
it's ideal if we do that tonight rather than him having to hold that part of the case over till the morning.
I very much hear your ladyship. I think, in fact, what little I had to say on this can be made by way of bullet points rather than having to take the court to anything else on it. But it might be convenient if I simply state those bullet points, which I think effectively concludes my submissions. The findings which His Honour Judge Gerald made were to the effect that what had in fact been agreed in 1991 and 1992 would have enabled the parties to pick up again later on their existing claims. That is clear from paragraphs 82, 88, and as my Lord Justice Zacaroli rightly says, particularly from paragraph 86 of his judgment. So he had in fact made a finding on the point. I do maintain, if I need to, that that finding would have been binding on Vacar, because it was a necessary part of the reasoning within that run of paragraphs, and also the reasoning on the question, which was before the judge, of whether Vacar thought he was occupying the flat as a licensee of Bilal. So it was relevant for the judge to find on the issues before him what had truly been agreed in 1991, 1992. But even if it wasn't binding as a matter of res judicata issue estoppel, in my submission still perfectly reasonable. It's just Bacon to take into account it was a finding and a recent one by a trial judge. I'm so sorry. I'm rightly reminded from behind me that that submission I've just made in slightly compressed form, the matters which is relevant are not only the findings in the subsequent paragraphs about Vacar's state of mind when he was saying the things he said to the trustee in bankruptcy and then to Mr. Jarvis in 2011. They're also relevant to the question as to whether Vacar considered he was occupying as a licensee of Bilal, which is addressed later in the judgment of paragraphs 121 to 122 of the Gerald judgment.
Thank you.
So those are my submissions in response to the 9 grounds of appeal. I say there's no reason to reopen the discretionary decision, and if there is, there can be no question but that it should be exercised in the same way again, for the reasons which I gave at the outset, which I've given throughout, which are given by the judge. In relation to the costs of appeal, I'm not sure I need to do more than adopt what's said in my skeleton argument.
Yeah. Yes, yes, Mr. Jordan.
My lady.
I think, given the shortage of time you've got, we're content to sit till past.
It's very very much obliged to the court for that. I'll try not to repeat things I said this morning. One point I do want to make is that the way that the Burkitt and James jurisdiction worked is if there was a delay beyond the limitation period, and the effect of the delay was to make a fair trial difficult, not impossible, but more difficult, and the delay was inordinate and inexcusable, then the claim would be struck out. And if there was doubt about whether the limitation period had expired, it would be struck out. And it was anticipated that a new claim might be started. And it's not the case that it's an abuse of the process of the court to bring proceedings where, because of the passage of time, a fair trial has been made difficult. It's only an abuse of the court if that results from breaches of court orders. So the whole premise of the idea that because Mr. Jarvis contemplated that there would be a new claim, that negates what he said about the huge difficulties of having a fair trial is incorrect. We are not making a complaint about the weight that Mrs. Justice Bacon attached to the factors that she identified in her judgment. Our complaint is about things that she didn't identify or errors of principle we made. So although this is an appeal from the exercise of her discretion, each of our criticisms in my submission fairly comes within the proper scope of this sort of appeal. I'm just looking at my notes just to make sure I've already said things. A lot of these things are things I've already said. One point I do want to come back on is the question of title and adverse possession. If I could ask the court to look in volume 2 of the authorities bundle at tab 68. This is the 6th edition of McGarry and Wade, published in 2000, the last edition to be published before the Land Registration Act 2002 came into force. And on page 1428 of the bundle, which is paragraph 21056, the authors address how the Limitation Act works in relation to registered land. And as my learned friend said, the proprietor's estate is not extinguished, but is deemed to be held on trust for the squatter. And then at the bottom of the page, about 5 lines up, it says, secondly, it's been suggested that until he's registered as proprietor, the squatter's title is merely equitable, so that any interest granted by him in the interim will also be equitable. This has been criticised, and the better view is that the squatter has a legal fee simple in the usual way by virtue of his adverse possession, until he bars the title of the registered proprietor. When he becomes a beneficiary under the statutory trust, this has the effect of nullifying the squatter's common law freehold. And that is still true today in my submission. If a squatter takes possession of a property held under registered title, once he's in possession, he has a title to it, has a common law fee simple which he can assert against everybody except the registered proprietor or somebody claiming under the registered proprietor. It is a title. And the effect of the Limitation Act is to make it an indefeasible title. So my learned friend's submissions on how land registration works, where there is a stayed possession action, firstly, in my submission, are inconsistent with the order. I said it wasn't appealed. Of course, the whole of the order allowing the appeal from His Honour Judge Gerald is being appealed, but there's been no appeal from that part of the order that says, assuming that Her Honour Judge Bacon, assuming that Mrs. Justice Bacon was right on the points which she allowed the appeal on, there's no suggestion that that part of her order is incorrect. There's no suggestion that the fact that the 1987 possession action would then remain stayed would preclude the court ordering that Bakar be registered as proprietor of the flat, and that's right. But even if that isn't the case, even if while there's a stayed possession action, you can't get registered, you still have your common law freehold title and you still have a defence to possession. You're still the owner of the flat for all practical purposes. There was a lot of discussion in my learned friend's submissions about the meaning of permanent stay and what Lady Justice Arden meant about that. I do accept that it wasn't an essential part of the decision, so it was an obiter dictum, but it was a considered one. And the way that it is discussed in paragraph 64 makes it clear that it had been discussed at the hearing, and that Lady Justice Arden was expressing a considered opinion on it. So it is an opinion that should be given respect, coming from the source that it came from. And the essential point is that in an action brought outside the limitation period, the fact that there's a stayed action brought within the limitation period is not a material consideration, and the court should order that the person who has established they've been in possession for more than 12 years is registered as the proprietor, regardless of the stayed existing action. My learned friend said I dealt with ground 6 briefly. Well, I did. That's not because it's a bad ground, it's just because there isn't much to say. If a judge is supposed to take into account 2 factors which are said to be of particular importance and she ignores them, then that's an error. And there's not much more to say about it than that. So I don't accept the fact I dealt with it shortly means it's a bad point. On ground 7, my learned friend said that Mrs. Justice Bacon did take into account Bakar's evidence, but gave it limited weight. And my submission is clear if one reads her, the relevant part of her judgment is that she didn't do that. She said she wasn't going to take it into account at all. And my learned friend says every time there is an application, a fresh witness statement has to be served, even if all it says is, I repeat the things I said in previous witness statements. There is no rule or practice direction to that effect. It would be completely pointless to do that, and it isn't the way that civil litigation is in fact conducted in practice. We did make it clear that well before the hearing that we were relying on the witness statement. We said that in our skeleton argument in reply, which is in the supplemental bundle. So in my submission, the argument that we couldn't rely on the witness statement without serving a new one saying, I still say what I said in 2011 is incorrect. My learned friend, in order to say that things had changed, has to rely on things that happened in a different action and findings made by a judge in a different action, which in my submission are not relevant or admissible in this action. As to the failure to treat it as a substantive defence, what was agreed in 2011, the way it was approached in front of Mrs. Justice Bacon was exactly the same way it was approached in front of Mr. Jarvis in 2012. And he didn't regard it as being a substantive defence. He regarded it as an important point to take into account in deciding if it was right to lift the stay. And all we invited Mrs. Justice Bacon to do was to take the same approach in 2022 as a previous judge had taken in 2012 in very similar circumstances. The suggestion that Vakar's evidence in his 2011 witness statement in relation to the agreement that he said was made in the Cromwell Hospital, that was not only that existing proceedings be withdrawn, but also that no future proceedings could be brought. One thinks about it, that would be a very surprising agreement for anybody to make, because it would mean that no matter what disputes about the property might arise, no matter what difficulties might occur, nobody could go to court under any circumstances. That isn't what his witness statement says, and that's not a fair reading of it. And certainly is not, as I submitted this morning, how Mr. Jarvis understood matters. Young lady, I could very much like, in a way, to repeat things I said this morning in answer to my learned friend, but I'm not sure that would help the court resolve the issue, so
Well,
I'm going to stop.
that's very pragmatic of you, Mr. Tom. Anything? Nothing. No, well, thank you very much indeed. So we'll move on. Swap round from here. Thank you very much. 10:30, please.